population of all seniors will be, something's here on your screen, sorry, will be seniors. So I think it's really important for us to realize that this number is going to be skewed. It won't let me move forward. I'm sorry. Technical difficulties. We'll be right back.
No, you can keep going.
There you go. How do I do it?
Where's the mouse?
Okay. So elder abuse, because of this, is now in a multi-billion-dollar issue, and it's yearly and it's rising. And because of this, Department of Justice is issuing annual reports as to what their efforts are in reporting to Congress, and these efforts to combat and filter through these fraud and abuse cases. Because of technological advances like here, documents and cases are being more readily available to not only us as attorneys, but the public in general. If you can imagine, cases are public records. So the types of cases that we're filing, dealing with probate and conservatorships, access to these individuals' finances and real estate property portfolios and such, is leaving them more susceptible to fraud and elder abuse. So, so with that in mind, I'm actually going to immerse you again. Let's talk about conservatorship and what that really means. Conservatorship is a legal relationship that's created when a court appoints someone to care for another person that can no longer care for themselves. So we know that this rises to what we call a fiduciary relationship. We know of other fiduciary relationships, right? Attorney-client, broker-agent, agent, client, whatever it is. There's all these other different types of fiduciary relationships, and conservatorship rises to that level. There are certain types of conservatorships that we can file. We can file a general conservatorship, which is what I'm going to be dealing with today mainly. So we usually will file what we call a conservatorship of person and a conservatorship of estate. The person is going to be you as an individual are asking the court to be able to take care of someone's medical faculties, their decisions, where they should live, things like that. And a conservatorship of estate is actually what you are going to want to look for as individuals in the real estate industry, as to, do they have this individual that is saying they have conservatorship, or this individual that maybe might have some other capacity like a power of attorney or something like that for someone? Do they have the actual capacity to act for them in order to transact business, including real estate? So that's actual conservatorship. It's going back and forth. Hold on, sorry. There's also limited conservatorship for developmentally disabled individuals. I'm not going to go into that too much today, but that's going to be situations where you have parents maybe trying to take care of or requesting to take care of their adult disabled, special needs children and such. So the general conservatorships are going to be mainly dealing with individuals that are aging or seniors. So that's what we will be dealing with today. I forgot to say, if you have any questions, to write them in the chats, and we are going to have a question and answer period. So we're saving all of that till the end. So the legalities of it, this is, always the fun part for me. So the burden of proof in conservatorship matters is going to be by clear and convincing evidence. In order to be able to utilize this form of fiduciary relationship out there in the world, really is what it is. Clear and convincing is really a burden to prove and we have to prove substantially that we are unable to manage this individual's affairs, financial resources, and that they are not resistant to fraud or undue influence. Okay. Additionally, the proposed conservator has to have taken all of the least restrictive alternative measures to accomplish this before filing this said conservatorship petition. These least restrictive alternative measures are going to have a list of factors that we're going to have to prove. So I'm going to go through those. You can look up the Supreme Court conservatorship case that restates the appeal on appeal that clear and convincing evidence is the state burden. So I'm just going to leave that there for you. But I'm going to go directly to the factors that prove this actual standard. When I am looking at a case as an attorney, I have to prove that standard. That's my job. And as I'm doing the intake with these clients, I'm asking all of these questions regarding the intake in order to ascertain if we have a case moving forward, if we met our burden, or if they already have other things in place that they don't realize they can utilize in order to assist these individuals outside of a conservatorship. So here are the factors that we're going to go through. So did the proposed conservatee create estate documents? It's so important that we always start there. Was there a trust? Was there a will? Were there financial power of attorneys, medical directives? Were there HIPAA directives, living wills? There's so many different types of contractual documents, including real property, trust transfer deeds, that we can look at in order to see if we already have least restrictive alternative measures in place in order to assist these individuals. Contracts, these documents that I've just stated and are here on the here in the handout as well as on the Zoom. These are all contractual documents, except for maybe last will and testament is still highly litigated, whether it's a contract or not, or lots of conversation regarding that. And actually last will and testaments, because of that, are required to be probated, whereas trusts are not. So what's really important to understand here is that there are certain elements of a contract. And as long as we have these elements of this contract, then we can utilize all these documents. Sorry, I'm having trouble with my we can use these contracts to conduct business. And what these contracts do for you as individuals in the real estate industry is it really allows you as a third-party vendor to rely on these contracts for whatever it is you need to do, whether it's through the sale, right? Whether it's through escrow, whether it's going to be through the loan process, whether it's going to be through the title process with Ticor Title, right? So I'm seeing waving hands in the back there, but anywhere you are in this process, you can trust as long as we have these elements of a contract. I'm not going to go over what those are, but a big part of the elements of that contract is going to be capacity, is going to be, do they have the legality to be able to contract? So that's going to be extremely important. And if we do have these proper documentation, then we don't have to go to conservatorship per se. When we have these documents and we end up in conservatorship, it's because we have individuals that are fighting. So we have maybe children or creditors or whatnot that are fighting over the validity of these documents. So that's really important to note. Okay. Other factors that we're going to look at is the proposed conservatee already enrolled in benefits like Medi-Medi, Medi-Cal, or Medicare, or other county programs like Inland Regional Center. So is the proposed conservator already named as a representative payee? That's going to be so important. And are there already documented issues of abuse? This is so key in these cases. And I think Tom is actually going to talk about what you actually literally need to look for from a title perspective as to when you are conducting business out there, what type of documents and what type of things you want to pay attention to that kind of raises red flags regarding these issues of abuse, okay? So pay attention to that. Police and adult protective services involvement is already, if we have that already involvement, we're going to court. So it's a venue for that already. Okay, so I actually want to take some time and talk about the general duties that the conservator is actually going to have to the conservatee, a person. So this is really important, even though I think technically, okay, all of you in whatever capacity you are in the real estate industry, you're not really going to have to deal with conservatorship of person per se, because it's going to, conservatorship of person really is what kind of medical decisions are we going to be making for this individual? So I'm gonna go through that and then we're gonna go to conservatorship of estate because these usually will be hand in hand. So let me see how. So number one, they always want you to consult with an attorney. So that's me. Okay, so consult with an attorney as to if we meet the burden of proof for this conservatorship. To determine appropriate level of care plan is going to be ideal and key in all of these cases. We evaluate the level of care that they're already receiving and what kind of care are they going to need to receive in the future. Do they plan to return home? This is key for you to really understand because the burden of proof, the burden that you have to prove also to know if they can return home or not, or if we need to move them for some reason is also clear and convincing evidence. So that's really important for all of you to know when dealing with these conservatorships of person. And a reevaluation after a material change in circumstances affecting the conservatorships, the conservatee's needs for placement or care are also things that you're going to be in charge of. This all ties into real estate, doesn't it? So where are they going to live? Are we going to need to sell their home? Are we going to need to keep them home? And under what terms and conditions? If we are going to keep them home, are we going to need to get access to equity in the house? You know, all of those things. And so deciding where they're going to live is really important as well. So that lends itself and carries itself into the actual management of the estate. So I'm going to go through the estate. And like I said earlier, management of the estate really is where everyone here wants to really pay attention because this is what you need and this is what proof you need, and we'll go over that in order for you to move forward with the sale or whatever it is that you are assisting with them in these real estate transactions. So management of estate. The conservator has to prudently manage for the benefit of the conservatee. So again, it's the fiduciary capacity to do your due diligence, really, to act as a prudent investor in order to make sure that we are managing all of the conservatee's assets for their prime benefit. You're going to need court approval for any sale of real estate property. When you're dealing with other contractual documents, when you're dealing with a trust, through a trust, when you're dealing with powers of attorneys, as long as the individual that is utilizing those power of attorneys or trust are adhering to the terms and conditions of that document and representing themselves per the terms and conditions of that document, we don't have to go to court. Okay, that's really important to note. But I think Tom's going to talk to you about what you want to look for when you're looking at these documents, okay, in order to know that they do have and who you are dealing with is the individual that has that authority to do that, okay? So prior court approval for anything conservatorship is going to be required. You are going to have to keep estate money separate and apart, interest-bearing accounts. I'm going to let you look at some of these here. I do want to skip to inventory and appraisal of assets. It's really, really important that you're going to need inventory and appraisal of assets. You're going to need what the appraised value that the court has set. And I'm going to be quite frank with you that it's maybe not as complete as these private appraisals that you're going to be receiving in outside of these conservatorship cases, but this is the requirement of the court, okay? Not only in conservatorship, but it's also going to be the requirement of court and probates. So that's really important to know. And the sale of these assets will need to be at least 90% of what the inventory and appraisal value is. So in a market like today, it's not going to be a problem, right? But when we are in a depressed market or when we are in a down real estate market, it's really hard to accomplish. So we would have to go into court quite often in order to request and ask the court to approve those types of sales regardless, okay? And then we also have to report on capital gains, income tax, tax consequences, impact on access to governmental benefits. All of this analysis would have to go into the management of the estate. Okay, so I think here, let's go over the timeline of conservatorship cases. I pause here because there's a timeline pre-COVID. And then there was a period of time when the courts were just completely shut down. And then now we reopened, and we are literally in the middle of another maybe potential partial shutdown, at least the court is. When I am hearing things like LA County and San Bernardino have stayed criminal trials, which is the case right now, it's not good news. We actually were just having a conversation before we became live here right now that the probate court in San Bernardino County literally is quarantined. So there's one judge in one department hearing all of the calendars, and she's hearing them quarantined at home on Zoom. So you can imagine what the calendar is doing. We already, as attorneys, not only in probate and trust and estate, but in our niche area of conservatorship, we already are short-staffed. You don't really hear attorneys quite often say, we don't have enough attorneys. But more and more, I don't think I've ever really said that, and this is being recorded. So I truly, that is the case right now in conservatorship. Just like I think we have not taken the time as a society, this is where I get on my soapbox, as a society to take care of what we eminently know is on its way, right? We know for a fact that the senior population is going to be 1 in 5 by 2030, yet we do not have the resources and things in place to support that. So that's what's going on basically in the conservatorship world. So I guess side note, if you want to be an attorney, come talk to me, only if you are going to be a conservatorship attorney, okay? So that's what's really going on here. And case in point, San Bernardino, is it the largest county in where? In the country? From a land standpoint. But even in that, there are 3 judges in San Bernardino County who are all being quarantined right now after a major shutdown and after we already are trying to get back to normal, everyone in the world, right? But in the legal world, in the conservatorship, getting back to normal with a caseload that is exponentially growing by the day. So you can imagine where we are at right now. But I'm going to go through what I think is the timeline for conservatorships right now, okay? So we receive a hearing date back approximately, hopefully 2 months. We are actually receiving them back 6 months right now. That's a fact, okay? In San Bernardino County, I'm talking about San Bernardino County only today for this conversation timeline purposes. Ex parte hearings, or what we call emergency hearings, we are seeing them a week out. Perfect. We normally pre-pandemic would see them the next day. So that's the difference there. But we understand now that ex parte really means ex parte. There's no ifs, ands, or buts right now about what we can bring to court and to the court's attention, because they will get mad at us and they will look me, the attorneys, in the eye when we are in front of them and say, what are you doing, right? You know better than this. So the types of cases and ex partes that they are actually going to hear right now are going to be physical abuse cases. We are going to be bringing those cases because those are the most important cases, right? And that has been actually the most important cases throughout this whole pandemic, unfortunately. So it's going to be the physical abuse cases. Then after that, they're going to hear those foreclosed cases, those cases where we have imminent dates of imminent foreclosure. So maybe a month out, maybe a month and a half out, we're not able to get extensions through the trustee foreclosure department or whatever that, whoever we're dealing with, right? Then we go in and let the court know, we've done our due diligence, we mitigated our damages, here's the proof. Now, can you please put a stay of sale, injunctive relief on the sale of this property, and let me go file a lease pendants so that we can get on with whatever it is we need to do, right? If we need to sell that property, if we need to remortgage that property, whatever it is, okay, then that we can do that at that time. So that's that, all right? Then what actually goes on in the case in between all that time is the rest of it. So the court will, in these conservatorship cases, assign certain individuals as such. So court investigators will go out as soon as the file, or as soon as the petition is filed and we have a hearing date, a court investigator will be assigned and they will go out and they'll just do their own investigative report to the court in general and for the court in general. The court appointed counsel, which is what I act in capacity sometimes when I'm assigned, will go out and will interview everyone and will act for the best interest of the proposed conservatee, whoever that is. And quite literally, at times, this proposed conservatee literally won't have a voice. So I quite often actually go out and talk to my clients as court appointed counsel, and they don't understand what I'm saying, or I can't tell if they understand what I'm saying. But my job to them in that capacity, in that role, is to make sure that everyone knows what's in their best interest or what at least we can provide to them for that, for their needs. Okay. Guardian ad litem. Guardian ad litem. So when I'm out there acting as guardian ad litem, or some of my colleagues that are acting as guardian ad litem, we are actually going out there as fact finders to the bench, to the judge. The judge is not going to go out there and interview people for these cases. So they send guardian ad litems to go out there and gain access really to everything. So there is no privileges, there is no attorney-client, whatever it is. We can, politely ask, but whatever we need as guardian ad litem in order to report to the bench, we better have access to. It's actually a better way to put it, right? Because we need to be complete and we need to let the court know, the judge know that everyone was cooperative in making sure that we completed a report. So, and the Inland Regional Service Center is going to be the other report. So by the time we get to whatever the first hearing is, or that approximate date for the conservatorship, if all of these reports are done, great. We're going to make a determination in court as to if a conservatorship is necessary or not. If these are not done, it gets continued again. Right now, another 6 months or so in order for these reports to get done. So everyone right now is really under the gun to really make sure that all these reports are done, whether it's a non-contested or a contested hearing. So these non-contested hearings are getting heard within the 6 months or so is what our timeline is right now. The contested hearings are taking maybe over a year, kind of like probates, right? So we know that. You want to receive the orders back from the bench stating that you have a conservatorship in place. In conservatorship, if there is an estate, a conservatorship of estate, you are going to be required to file a bond, whatever that bond is based on the value of the conservatee's estate. You are going to look for letters, which is the actual one-page judicial document that your client's going to need in hand as proof that they have authorization to act as conservators for these individuals. And you're going to have an inventory and appraisal shortly thereafter that needs to be filed. In San Bernardino County, these inventory and appraisals used to be hearing set dates. Now they're file by dates. So we have these file by dates where we have to file the inventory and appraisal, and my office at least always hands that to or forwards that over to the real estate team that's taking care of the sale of property if that's the case. The care plan is going to be filed. That's more so conservatorship of person. And what you want to look at really is the petition for sale of real estate property. So we in conservatorships, again, will be required to request to petition for real estate sale. No ifs, ands, or buts, even with a bond. Okay, so that's important to note. We receive that order. And then when we have a buyer, we go back into court and we petition the court for confirmation of sale. So that's how it works in conservatorship. I think in probates, if you were comparing it to probates, in probates, you can have bond and then pretty much conduct the sale as if it was a private sale, except for certain notices we're required to give to the court. So that's that. I'm going to round it out and I'm going to close it. What I want to actually talk about before I hand it off to Tom is,
the questions towards the end as well. So
oh, okay, the questions also. So there are certain planning progressions that are very complementary to conservatorship. So the very first thing actually, and I put it at the top here, that we usually will actually, quite frankly, be forced to deal with because of the types of cases these are. They're very much like family law cases, right? These conservatorships, because you're dealing with families. And a lot of the times, if we're going into conservatorship, especially if we already have power of attorney documents in place, or especially if the family is not being cooperative with each other, it's going to be because other members of the family are worried about maybe one family member isolating their parent, their grandparent, or not properly taking care of them physically or abusing them financially. So when we go into court and all of these timelines and all of these hearings are being set and all of these individuals from the court are being sent out there to create their reports, the family, their first concern is going to be visitation. So the judge is usually going to send us to mediation so we can figure that out. So it's family planning, really. And we literally figure out a visitation schedule, who's allowed to see, for example, grandma alone, for how long, or supervised, who's going to supervise, what does that look like, you know? And you can imagine what COVID, on top of all of that, has done to this type of planning. So it's visitation and family planning. Along with here, I don't have it on here, but there's going to be a caregiver contracts, caregiver, plans, things of that nature. And then substituted judgment during a conservatorship. Substituted judgment really is if we have a conservatorship in place, already in place, are we able to ask the court or the judge if we can, by substituted judgment, ask the bench to create estate documents, ask the bench to amend estate documents during a conservatorship. Of course, a lot of the times it's going to have to be, we're going to have to provide proof that maybe they were already in the middle of doing that. Maybe we have an attorney that can act as a witness as to what the intent or terms and conditions of that was supposed to already have been, things of that nature. So substituted judgment is something that you might actually see out there as well when you're, dealing with these clients. Then benefit and long-term care planning. Benefit and long-term care planning is such a huge extension. I actually have my Medi-Cal expert here in the room. So benefit and long-term care planning is so important when we're dealing with the senior population, when we're dealing with conservatorship in general, even when we're dealing with, trust and estates in general. So, as people progress, unfortunately, a lot of these mental incapacitations, a lot of the times, for example, dementia or Alzheimer's or things like that, there's no going back from it, unfortunately. It's a progressive situation. So how do we plan for that eventual long-term care needs? So that's a huge portion of what we do for these conservatorship clients. And special needs planning. So special needs planning really is, so when you're dealing with conservatorships, you're dealing mainly with mental incapacitations. And when we're dealing with special needs planning, a lot of the times we're going to have individuals that have physical limitations. So the combination of that and what we can do for them and the resources available to them is all through special needs planning. And of course, I as an attorney, and if there's any CPAs here, I as an attorney am always thinking about the tax planning. From the minute we're talking to those clients, when we're doing those intakes, when we're categorizing them into, do they have special needs? Do they benefit tax-wise? Planning for that. Are they seniors? Are we moving them from one home to another home in the same jurisdiction? Are they crossing county lines? Are they distributing assets as gifts to children or grandchildren? All of that, the tax planning in that we're thinking about as well. And then of course, unfortunately, probate. So we are always going to, it's such a difficult subject, but everyone passes away, and whether you plan for it or not, all across that spectrum, we're going to deal with either an administration of an estate through an estate plan or probate, really, at the end of the day. So probate, more often than not, when I'm dealing with these conservatorship cases, is the outcome of what we need to do in order to wrap up their estate for the benefit of their beneficiaries later on when they're gone. Okay.
Margot, somebody took in the question. It says, many times there are children that has a parent going into an assisted living facility and are seeking medical assistance. The parent owns a home and they are seeking to transfer the home. Can you talk about asset protection?
Yeah, so medical asset protection is something that we do a lot of. Depending on what type of care they're receiving from and what type of facility it is, they may or may not be able to partake in Medi-Cal. There's daily acts of living. I forget now. There's 7 of them, Rose. There's, for example, bathing, cleaning, dressing, things like. I think there's 7 of them in which they have to. We kind of check the box to see if they fit in any of those categories. And I think if they have 2 out or more out of all of those, then they would be a good candidate for that type of planning. In addition to that, I think a lot of people think that you have to have very little assets in order to partake in the Medicare, Medi-Cal system. And really, there are certain assets, without getting, this could be days, this conversation. There are certain assets that are exempt from actually benefiting or qualifying, and your primary residence is one of them. But it's not exempt from the recovery process from Medi-Cal. So we assist clients in qualifying for it. And then if they need to, for example, go into a long-term care facility, then we assist them with planning around that. What we all know really, truly, for a majority of these people, are their major asset, right? Is their real estate property. So we assist them in planning. Do we keep that real estate property, put it in some sort of asset protection plan in which we can utilize later on for their care and maybe bring them back home? Or do we sell it and gift it out into an asset protection plan so that they can utilize, I call it, utilize this plan as additional long-term care if they need it? So what that all entails is a consultation, really. However, it's doable, and we can assist with that.
So then another person for the question is very similar in nature. It says, I have a question regarding medical benefits when a client owns their home and needs to pull money out to pay for bills and care. Will that jeopardize their medical benefits?
For Medi-Cal in particular, it could.
So I don't know.
But
I don't know if everybody in there could hear me because I didn't open my mic.
Oh, I'm sorry.
Restate what it is.
So I think you're asking if they take loans out on the property, will that jeopardize the money that they're receiving from the benefits, the Medi-Cal benefits? Really, that's what you're asking, or what they're asking?
Correct.
And it could. Or maybe not. It depends. I'm such an attorney. I just caught myself there. It really, it depends. Huh?
It can be protected.
It can, yeah. I told you I have my medical expert here, and she's shouting things at me. So, yeah, Rose, you want to come up here? It can come up here. Yeah. It can be protected, and a lot of the times how we protect it is we will take. We work with reverse mortgage individuals who will take out a line of credit or actual lines of credit on real estate property, but not utilize it. So if we can do that and only utilize these funds and resources as we filtered it through their asset protection plan, then we're really spending it down. We're really utilizing those resources for exempt, things like care, things like that. So it really just depends on how we categorize these loans. So yeah.
Follow-up or continuation of that question says, if it's in a trust, does that change anything?
If it's in a trust, does that change anything? That is such a broad question because there's literally hundreds of different types of trusts. So out there. So, actually Medi-Cal in general has stated, I think it was 2 or 3 years back, that if your estate is not being probated, then Medi-Cal can't come back in under certain circumstances, which we're not going to go into here, but can't come back in and reach into the estate that's not in probate for these resources that are, or for these funds that are due back to them.
It depends on the titling of it. If it's
Yeah.
joint tenants and-
Yeah, and also depends on the titling, and it also depends on how did you,
Versus the vesting, if it was held in a family trust as compared to.
yeah, that's always better protection for Medi-Cal purposes. But I qualify that because there have been recent cases in which they have been able to reach into revocable trusts in particular,
Right.
and which is what the majority of people have, right? So,
Another question came in, does what we're talking about need to be done prior to selling their home?
no.
Yeah, they're saying they can't hear me asking the questions, is what they're saying. See if we're-
Oh.
All right, I can come up there either way.
Does this planning need to be done prior to selling the home? No. We actually went through this with a huge case that we have right now. We were literally in the middle of escrow. I'm trying to figure out the, we were in the middle of escrow, and then the facilities, I don't know if everyone knows, but the facilities, local facilities literally shut down again. No one's able to go in and visit again. And we needed doctor notes and such for this escrow to verify that we had authorization, or our client had, our client's representative had authorization to act as power of attorney, and we couldn't get those doctor authorizations. And our Medi-Cal application is pending and probably going to be approved at the same time. So we literally just went through this, but we already did know that, no, we can gift assets out as long as we receive it within the same month. There's all these technical rules within the same month, and gift it out in increments to individuals and then to the special needs trust or an asset protection trust. So I don't know if that made sense, but
All right, let's finish this so we don't run out of time.
Yeah.
Over these people. Let's go ahead.
I'm gonna hand it to Tom, and then if we have time for questions, we're gonna do that. Thank you.
All right, all right. All right, so guys, obviously, I'm a little taller than Maribel is, so I'll put that back up for half a second. And we will pull up the other PowerPoint here. Guys, we are going to still turn it back over to questions throughout this as well as at the end. The goal was to go an hour from 10 to 11, but if we go over, it'll be based on the questions and answers at the end. So it'll be up to you guys as to how far we drive the ship here. And I'll do a better job of making sure you guys hear the questions. Our magic man, Mr. Tom Bernath, and take it away, Tom.
All right, well, thank you. Gotta come in here. I'm just looking at Ryan sitting there on a stool. It looks very professional there. Good morning, Maribel. Thank you very much. That was very informative. I'm not gonna do, I do have a PowerPoint, but I'm not gonna follow it verbatim. I think everybody can read it at their leisure. And one of the things that I always say when I do piggyback on some of these presentations with attorneys is because I'm in the title side, and we leave the lawyering to the lawyers. And after Maribel's presentation, we can see why we leave the lawyering to the lawyers. It's very complicated when it comes to conservatorships. So I'm going to focus mine on from a title standpoint, what we're looking at and the things that we need. Of course, I always like to start off with some funny business if we can, but I'm technically challenged, so I don't know. I think I hit the first arrow here going forward. I didn't bring my 15-year-old with me to help me on the technology, so you have to bear with me. But I started Happy New Year to you all. I started a new regiment workout. I drink while I work out. I call it Bacardio. Now it's working out really well. That's my trainer right there. We meet every day. This I thought was pretty interesting. I was hiking as part of my New Year's resolution. I came upon the sign: "Hunters, please use caution when hunting. Pedestrians using walk trails." I'm thinking to myself, where am I at? And I do tell you, this last few years, the last couple of years, really have caused a toll on a lot of us. And I think this fits well with our presentation here. Congratulations, you've gone from carefree baby boomer to care needy elderly person in record time. And I do think that that's had a lot to do with the last couple of years. Don't you agree? I mean, it's just been absolutely crazy. And here's my New Year's resolution: be awesome. Check. So, but okay, let's get on to So, of course, yeah, if you listen to the crowd, and we do have a full house here and nobody's laughing, that's probably why I'm in the title business and not doing stand-up comedy. But again, my presentation is not legal advice. It's just for you to use as some helpful information, and more importantly, keep Maribel's information handy, because one of the things that we look at from a title standpoint is when we're dealing, she brought up the fact that, there's going to be probably 10,000 baby boomers reaching the age of 65 in the next 10 years every single year, if not more. So we're going to see a lot of elderly individuals owning property, and some do take some time to work on their estate planning and some don't. And those that don't, we're going to, we have some issues on. So, and I think we owe it to ourselves as an industry to look out for, I think, one of the most vulnerable part of our population, and it's the elderly, and make sure they're not being taken undue advantage of. And that even falls on the shoulders of our title people. So when we're getting a transaction, we're looking at a transaction, we do look at, I think the most important thing that we look at is signatures. The signatures can tell a lot as to possibly there might be some issues there with the parties that we're dealing with. And we get a lot of questions. Maribel brought up a power of attorney. This power of attorney is being used so the owner can sell the property. One of the first things we're going to ask from a title standpoint is, why can't the principal sign the documents on their own behalf? What's the issue there? Are they not in town, or is there a capacity issue? Could it be a medical condition that is preventing them from being able to sign? I always use the example of my grandmother, who passed away at 93, but up until she died, she was she was sharp as a tack. She knew exactly what was going on. She can look at a picture from 50 years ago and tell who was on it. I can't look at a picture of my hallway and tell you who's in that picture. But she had a physical condition where it made it very hard for her to sign things. So that could be the possibility as well. So it's not that a power of attorney cannot be used, but I think a power of attorney, we need to ask additional questions. And of course, probably 9 times out of 10, when we're dealing with a power of attorney where an elderly person is on title, the reason why it's being used is because they have a capacity issue. And so then we look to see what type of power of attorney it is, and does it have durable provisions? And more importantly, when was it executed? We get some that they executed 2 weeks ago, and they want to use the power of attorney. Well, if they lack the capacity to sign anything, then the power of attorney, they lack the capacity to sign the power of attorney. So that's where we start getting into a discussion as to what's the next steps for this person to get authority to be able to sell the property. And that's where we probably direct you to Maribel's group to talk to them. So, but when we do get involved in a conservatorship, some of the things that we're looking for is, and documents we will ask for, is the order authorizing the sale. We'll more than likely ask for a copy of the petition that was filed, just so we can get a little more information. We'd like to see who all was entitled to receive a notice of the hearing and a copy of the order. All orders have an appeal period, including that particular order has an appeal period. So we'll have to look at that. We'll also look on our own side. We'll take a look at the court docket and see what's been filed, what's happening with that particular case. Has there been any objections filed that we may want to dig a deeper dive in? Typically that doesn't happen, but there are times when there may be a situation where we want to look at things a little more deeper than just getting the order and the copy of the petition. So we will be asking for those things so we can get to a point where we can go ahead and close that transaction. We will need a certified copy of the order to record. We'd like to record it. Now that's not always the case. Sometimes we don't get that at time of closing, and depending on what's happening, and we may be able to rely on just a copy of the filed order, especially if we do our own dive into the court docket. We can see that it's actually been filed. So now, one of the things that we have, one of our underwriting guidelines in for my office is anytime that we are dealing with a professional fiduciary that is, sound like fiduciaria, that's the new COVID variant, I think. But anytime we're dealing with a professional fiduciary, I apologize. I keep going back to my stand-up comedian days. It's a good thing, that Maribel talked about all the conditions to declare somebody incompetent, because my family and wife, they think I'm crazy every day. So, anytime we're dealing with a professional fiduciary that's a conservator, one of the things that I have to do as part of our underwriting procedure and getting approval is I have to go to one of our underwriting counsels and seek approval to on that particular transaction when we're dealing with a professional fiduciary, whether it be the public guardian or other professional fiduciary that is acting as the conservator on behalf of the conservatee. I think lastly, so we are staying on our timeline. I knew that my portion was going to not be that long, because I think the most important thing to take away from this particular presentation is it's always good to have a relationship between the attorney and the title company, because we interact probably more. We will interact more on that transaction than we will with anybody else, because we're trying to get documentation, trying to get information, and get to a point where we can rely on those documents. So that I think is very critical. I have relationships with a lot of attorneys that do, whether it's conservatorship, probates, estate planning, and it does have a tendency to make the process a little more streamlined because of that. So. But one of the last things I want to bring up is we refer to them as a foreign conservatorship, which is any conservatorship outside of California, and what authority and powers that the foreign conservator has to deal with to be able to sell a property in California. Now, there is a process in California that they have to get and I want to use the term registered, but I don't know if that's the right term or not in California if they're a foreign conservatorship. And I do have some information in my PowerPoint presentation that does address that. But again, we like to leave the lawyering to the lawyers and not get too involved in the legal aspect and those things that have to be done through the court system. And so any questions that you may have, if you come upon one where it is a foreign conservatorship, and what processes and steps they need to take to become registered so their authority and powers can be recognized here in California. So okay, I briefly talked about power of attorneys, but we do sometimes we'll come across a document executed by somebody that possibly had a capacity issue. Those can raise concerns for us, and we'll have to dig deeper and see if we can rely on that transfer. Sometimes we can, depending on the fact pattern, sometimes we can't. Okay, again, I don't go word by word on my PowerPoint. But I do want to make sure I addressed everything that I wanted to address. And as I mentioned earlier, I knew that our portion of this presentation from a title standpoint was going to be relatively short, much shorter than Maribel's presentation, because I think there's more involved in the legal side, getting to the point where you can get somebody to be appointed as conservator and get to the point to be able to sell a piece of property. Okay, so Ryan, we're at question and answers, but again, if you like this presentation, I'm not very technical, but please do like our post or post a like on Ryan's webpage. So.
All right, well, that is Mr. Tom. We're calling Miss Maribel back up. I'm going to try and moderate some of his questions and escape from the screen share on that one. Let's do stop share. Even Victoria might be able to see some of the questions. Vic, if you will check on Facebook and see if there's any there. All right, let's see here. Benefits. That one, I think we already answered those. Q&A. Looks like there's 2 in there. All right, can we get a copy of their PowerPoint and their contact information? The answer is yes. That's going to be for Ms. Blanca. If there's anybody on here that wants to get a copy of that as well, we will be doing that. The presentation will be obviously posted up to YouTube and on our Team Title Guy Facebook page. So we will be sharing. Blanca looks like she just mentioned in here. Did you say that there's a Medi-Cal expert in the room? Can I get her contact information or his contact information as well? The answer is yes, yes, you can. So Blanca, we'll make sure that you have that as well. Guys, this whole idea here is a collaborative forum to be able to help people in growing their business. And so coming together as a team is kind of a big deal. And making sure that we have those resources. And so we have some amazing business partners that we work with. And so it's all about that. Joan Lucas, I don't know, Victoria, if you can see in the comments, there's other folks that are asking for that as well. So you can either text, call, email, direct message. We don't really care how you reach us, just reach out. I think what we're also trying to say is that when it comes to our world of being law or title, nothing necessarily closes in a vacuum, and we have to be able to willing to work together to find solutions to people's challenges. So Victoria's got her speaker back on over there. You know, that girl is distracting in the back, and it's not even Taco Tuesday, and she's not even thinking about it yet, but we are close to the weekend, so maybe that's part of it. So who knows? Girl is ready to go. She's got dancing shoes on, and we're just here for the good time at the same portion. Ms. Maribel, I know that we're right at the 11 o'clock hour. Are there any closing thoughts or ideas you'd like to share?
No, I just want to say, here we go again. I just want to say thank you so much for being here. Whether you knew it or not, this is one of those most difficult conversations to have with people. You know, aging is one of those difficult conversations, and what do we do? But I urge you, because you are here, I urge you to continue that work and what you're doing, and be mindful when you're meeting with clients, especially and particularly when you're dealing with agents of individuals that can't care for themselves. That we maybe as a collective take extra care in the transactions that we are conducting. Please, if you need anything at all whatsoever, reach out to us. Thank you so much. That's it for me.
I have a couple of questions, if
Oh.
you don't mind.
Wait a minute.
So, only because I
Here it
know.
comes.
Oh, the
On that
sirens are
note-
going off. We must have to go home. I don't know.
Is
But
that, what is that? That is my computer.
I have no idea. Tom, did you break my computer? All right, well, that might be it. All right, let's. I guess one of the timers, Tom had something.
Okay.
I'll blame Tom.
you know, I probably cut the blue wire, I guess. I don't know.
Yeah.
But I only because I don't know, and I always like to learn something. I thought it was interesting that you made a comment about getting a judgment to amend estate planning
Oh, I'm
documents.
sorry. I was
Um,
looking at it. Can you repeat?
I've never heard of this before, and
Yes.
I've never encountered it. But you had mentioned that you can get a judgment to amend estate planning documents.
Substituted judgment.
Substitute judgments to amend. Can you expand on that a little bit, just for my, is that like, if they were in the process of amending a trust or a will or something, and they didn't complete it because of the issue with capacity or the conservatorship that they needed, then
You
you
know,
can go and finish it off for them?
Yeah, I don't know how often it's done, but I do it quite often. So, and I've talked to other or my colleagues anyway, that are conservatorship practitioners, not so much probate, but really truly conservatorship practitioners, because we need them alive, right? In order to do a substituted judgment. And we do need to prove by clear and convincing evidence again, that it was their intent.
To
To-
change the trust or amend
Or
the
to
trust or
update.
something, or update it? Okay.
And actually, I've been bringing some petitions to create trust documents as according to the intestate succession rules that are already in place in the probate code. So
Okay.
we just started doing that during the pandemic, by the way, so I'm going to let you know how that pans out. And if it works.
That
So-
You
is-
guys,
you
you
know-
guys did bring up, both of you brought up powers of attorney, and so if I'm alive, power of attorney can be used. What happens if someone dies?
Powers of attorneys are void and invalid upon death.
Can you repeat that for the people? in the
Period.
back?
Powers of attorneys are void and invalid upon death.
Okay.
Yeah.
No, because that gets brought up quite a bit as to what it is,
Yeah,
and so sometimes that becomes
It's-
problematic.
it's meant to be a contractual document to be utilized while they're alive, really, and that's it. So once they're gone, if there are trust documents or other estate plan documents in place, then we will utilize those documents.
What happens if a property was held in a trust, right? And now both are the parties, the trustees are deceased, and the successor trustees and the family can't find the trust, because lately this seems to be an issue.
Yeah, then we have to go in and ask for direction from the court, petition the court for direction.
Yeah.
Letter, what we call letters of instruction.
And I think that's a good point because we are seeing more often now that people can't find their original power of attorney. They had,
Yeah.
the attorney in fact has a copy of it.
Yeah,
They want to act on it, but they don't know where the original is.
So-
And that causes a problem for me as a title professional and an underwriter. Because if the attorney in fact doesn't have the original, then I have no way of knowing if it's been revoked.
so a lot of the times, if we don't have original documents, if there is an attorney that is willing to verify and certify
Yep.
or copies as originals, which I do for my clients and solely my clients, actually, then you can do that.
Yeah,
But
I've accepted
yes,
a certification from an attorney that drafted those documents and I've accepted that as well. But if they can't get that and they don't have the original, whether it be a trust or a power of attorney, I have no way of knowing that was, somebody found it in the desk drawer and it had been revoked, but they still had a copy of it and then they're trying to act on it. So just make it.
or
a little-
fraudulently created it.
Yep, yep.
Yeah, so, yeah,
Okay, cool.
I feel like we could do a stand-up comedy.
We can, but I just thought
He's
that,
rubbing off on me.
What you didn't know is that Victoria's been handing out shots of vodka in the back of the room with the lemonade spiked over there, lemon drops or
No,
something.
no.
No, just totally kidding, totally kidding. That was,
Scratch. Maybe.
well, I just think, and I'll close with this because I know that we like to stay on everybody, be respectful of everybody's time, but I just think this is a very important topic. Because I think we owe it to ourselves to take care of our elders and make sure that they're not taken undue advantage of. And as a professional in the real estate industry, whether it be title, escrow, or otherwise, we're on the front lines and we need to be looking out for these people. And if there's something that doesn't seem right, we need to dig deeper and find out what's going on and make sure that we're taking care of them and getting them what they need to be able to enjoy the rest of their lives. So, and not let somebody just take advantage of it. So, but thank you for your time. Happy New Year, everybody. Maribel,
I
thank you
got two
for your
more,
information.
one question for both of you. Maribel, if someone's watching this or if they're watching it afterwards, what is going to be the best way, number one, to get a hold of you? And two, creating expectations we found is a really big thing. So if they reach out to you, how quickly can you or your team potentially respond back and at least acknowledge the request?
We do our acknowledgements in the office, immediately by that day. So actually, if you call my office, and I'll just give that phone number, 909-256-6702. Anyone that answers the phone can assist you and get any message to any of us. So I work with a bunch of really good professional people that are really experts in their field, and our person, whoever it is that's answering the phone, can field you to whoever you need to be with. So.
And
So
then
thank
Tom,
you.
same question for you. I know the answer, but I'd like to hear it directly from the magic man himself. What is the best way to reach Tom Burnett?
Well, I always like to work through the reps that are out in the field. So if you have questions, issues or concerns, get with Ryan, get with Victoria. I like to keep them plugged in so they know what's happening on the street. So if there is a common thread, we can collectively come together and see if we can address that particular question that keeps coming up time after time. I'm always available by email, which you can get my contact information from Victoria or Ryan. And you can email me anytime, whether it's a transaction that we're handling at Ticor, or you just have a general question from a title standpoint. Understand, I keep we let the lawyers do the lawyering and I do the titling. So I can't give any legal advice, but I'll give you my opinion. and do the best I can from a title standpoint. And if you need to go seek additional information or advice, then we'll direct you to who you need to go talk to. But I like to work through Ryan and Victoria so they know what's going on.
All right, guys. Well, that pretty much sums it up for today. And see, yeah, I'm not, see, I gotta step back here. You see? Anyways, walking up like, hey. Anyways, guys, hey, we love what we do. We're passionate about it. We really want to help others. So thank you for joining us here today. Be sure to give us a shout or either of our partners here. And we look forward to seeing you soon. God bless you guys. We'll see you on the next one. Tuesday morning, there'll be a kind of a little bit of a review of what we're kind of going through here because we have her on our Tuesday Market Minute this coming Tuesday. And didn't get enough? Come on back on Tuesday. We'll see you.